I would note from the letter to the law that the law clerk provided that it is well within the right of this House to request documents. And I'll quote from that letter in page 2. I note the order is an exercise of the House of Commons' power to send for documents. This parliamentary privilege is rooted in the preamble of the Constitution Act 1867 and Section 4 of the Parliament of Canada Act. Parliament of Canada and this chamber is able to ask for documents. They're able to ask for documents to be produced. They're able to ask for documents to be made public. But this government actually doesn't share a great relationship with following House orders. Do we need to think about Winnipeg Lab documents where they took the government to court to prevent those documents from being public? They have subsequently been made public. But this government was willing to take the Speaker of the House to court to prevent the documents from being made public. And you could wonder why we would include, which, by the way, this motion was supported by a majority of members in the House, why we would include the ability to send these documents to the RCMP should they wish to receive them. Because the RCMP has actually identified multiple occasions where they themselves haven't been able to get documents from the government. Do we need to remind the government members about SNC Lavalin? Do we need to remind government members about We Charity? Do we need to remind government members about not providing or waiving parliamentary privilege in providing documents for the foreign interference scandal, or again, the Winnipeg Lab documents, as I already mentioned? There are criminal code provisions for breach of trust. There are criminal code provisions for a breach of trust by public officials. It would be completely up to the RCMP whether they choose to look at the documents, whether they choose to allow those documents to inform an investigation if an investigation exists. We are not confusing directing with making sure that the RCMP is informed. But this is a government who has a challenge with the definition of the word directing when we think about the Prime Minister directing an Attorney General to provide a break for a well-connected Liberal firm, or the Minister of Public Safety directing the head of the RCMP to improperly release documents with respect to the very unfortunate and tragic shootings and killings in Nova Scotia. But this speaks to a broader issue of disrespect for Parliament, Madam Chair. The government seems to treat this place like an inconvenience. They seem to treat the House of Commons like an inconvenience, parliamentary committees as an inconvenience. Ministers routinely do not show up to committees when invited. But let's just take a step back about the respect for this place that this government does not have. During the pandemic, the government tried to shut this place down and give itself unlimited taxing and spending powers without the oversight of Parliament for 2 years. They prorogued Parliament in the middle of a scandal investigation of the We Charity issue in order to avoid that investigation from being completed. I already mentioned they were willing to take a speaker to court to prevent the release of the Winnipeg Lab documents. And how could we forget the Emergencies Act that this government invoked provided no evidence to Parliament, had ministers going out and giving press conferences, giving misleading and false information to members of the press on the basis for which the Emergencies Act was invoked in the first place. This is a government who has no respect for the House, no respect for the Chamber, no respect for the orders or motions that are passed in this place. This House is merely an inconvenience for the government. If the government cared about institutions as it says it does, it would abide by motions passed in this House by a majority of members. It is no wonder why Canadians are losing faith in their institutions. This government doesn't even have faith in this chamber or this institution themselves. Why should it expect that Canadians will continue to have faith in this institution? If conflicts of interest, Madam Chair, were cookies, this government will have found its hand in the cookie jar way too many times. Aga Khan conflict of interest. Spouses of ministers or spouses of very senior staff individuals lobbying improperly for their clients, especially during COVID. SDTC, the entire purpose of this debate tonight, where the AG found 186 conflicts of interest and called into question almost $400 million of that fund that was spent. The self-dealing at SDTC, completely unacceptable. But Madam Chair, I have a theory about why the government has a problem understanding what conflicts of interest mean. I believe that Liberals believe that everyone under all circumstances will always act in the most altruistic fashion. That is, they believe that if someone's intentions are pure in their heart, they can do no wrong. But instead, I actually think, which happens to be reality, is that the temptation overcomes those altruistic intentions. And conservatives believe that even though altruism and pure intentions are present, we have to protect against that temptation for people to act improperly. And it has nothing to do, Madam Chair, with whether there is an actual conflict of interest, even though we know the Auditor General has identified 186. It has to do with whether there's a perception of a conflict of interest. And there is no better example of this than when the Prime Minister tried to appoint Governor General David Johnston as the special rapporteur. Governor Johnston, a very eminent Canadian, a wonderful person, a good man, a great Canadian, but very, very wrong for the choice of the role that the Prime Minister believed he could do. Why is that? Not because there was an actual conflict of interest, although there might have been an actual conflict of interest, but that there was a perception of a conflict of interest. When reasonable people ask, why are well-connected insiders getting rich? That tells me all I need to know, Madam Chair, because a conflict of interest exists. It's not about whether your heart's in the right place. It's not about whether your motivation is pure. It's not about whether there's an actual conflict of interest. It's about whether there is a perception, whether a reasonable person could perceive there to be a conflict of interest. For some reason, and there's lots of lawyers on the other side, Madam Chair, I have a hard time understanding why members of the government time and time again fail to grasp a very basic legal concept of conflicts of interest, because they continually offend it. And it is a simple legal test. It's a question of law whether a conflict exists. It is whether there is a perception of a conflict by a reasonable person. And as I mentioned, when regular Canadians are saying, hey, why does it look like well-connected liberal insiders have the inside track in getting rich off of government contracts, like, they're reasonable people. In the United States, there's something called the False Claims Act, where whistleblowers can get financial compensation for pointing out frauds on the taxpayer that are then recovered, where money is recovered from these frauds that are perpetrated on the taxpayer. We should seriously consider whether Canada needs whistleblower protection laws like that enhanced such that they would provide financial compensation. Given the frauds that we've seen exposed, that the fact that the government did not support a very reasonable block bill on enhancing whistleblower protections. This is something we should look at, Madam Chair. Think about Arrive scam. Maybe we would have found about that sooner. Maybe we could have recovered government money sooner. Maybe we could have prevented more money from being wasted. But let's go back to SDTC for a minute and talk about the actual conflicts of interest that existed. As I mentioned, the Auditor General found 186 conflicts of interest, and an individual, and I don't enjoy naming individuals in this House, and I try not to on many occasions, Ms. Andre-Lise Matteau was a board member at SDTC. And to be fair to this individual, I've never met her. She, for all I know, is a very wonderful person, and she took on that role to do a great thing for the country when she was asked to sit on the board. But the Auditor General found conflicts of interest, that this individual was present and voting in favor of awarding money to companies where this individual had a financial interest. It would appear that the temptation to enrich oneself overcame the initial pure intentions. But it gets worse, Madam Chair. Even in the face of an investigation by both the Auditor General and an internal investigation, this individual, Ms. Matteau, was given a promotion. She was appointed to the board of the Canada Infrastructure Bank. Now, why would the government appoint an individual who is the subject of an investigation for self-dealing and conflicts of interest to another job? And the facts were well known to everyone at the time of the appointment. And even if they weren't well known to those people in government at the time, Madam Chair, those facts were made public eventually, and everybody knew. The government did not have to wait for the end of the investigation to see the documents that show that this individual was present in board meetings where she approved or were partially approved money going to companies in which she had a pecuniary or financial interest. Getting these documents is a right of this Parliament and this House and this Chamber and all of us as members in this place to request documents. We've established that it is a right of this House to request documents. They can be made available to the media. They can be made available to the RCMP. When those documents are provided to this House, maybe some members will post them online. If the RCMP wishes to ignore them, that would be up to them. If the RCMP believes they may not be able to rely on those documents in an investigation, that's their choice. If a member from the Justice Department who's being consulted on a breach of trust or breach of fiduciary duty, or breach of trust by a public official, which are criminal code acts. If they choose not to rely on those documents, that's up to them. In nowhere in the motion today or the original motion does it suggest that the RCMP take any action, that the Auditor General take any action. It is up to them. The Auditor General, even though she has said she did not find any criminality, that's not what the Auditor General was looking at. The Auditor General was looking at whether there were conflicts of interest. And boy, did she find a lot of them, 186 of them, calling into question up to $400 million of the fund that may have been improperly paid through self-dealing or to ineligible recipients. I would completely defer to law enforcement on how they choose to deal with the information should it be made available to them. Unlike the current government, who tries to strong-arm an Auditor General in a criminal investigation to help their friends, or tries to improperly pressure, whether it was directed or not, whether it was wise for them to improperly pressure the Commissioner of the RCMP to release information about the firearms that were used in the absolute disgusting tragedy in Nova Scotia while that investigation was underway, because this government had a piece of firearms legislation that it wanted to benefit the politically of having that information made public. So, Madam Chair, I would welcome the Government House Leader's questions on any of these matters, and if he wants, we could go back and forth for the full 10 minutes. Thank you, Madam Chair.